Good afternoon, and welcome to another episode of the Kantor Insurance Podcast. For 30 years, we have been representing individuals with life, health, long-term disability, and long-term care claims in dispute with their insurance companies. Today, we're here to talk about long-term care. So, can you explain the common reasons why long-term care claims are denied and what steps individuals need to take to protect themselves?
Well, I think in order to do that, I should give a brief, maybe historical perspective on long-term care insurance.
Please.
It's a relatively new kind of insurance that came into being in the 1980s. And at least from my perspective, when invented, the insurance companies made gross miscalculations. They anticipated they would sell these policies to people in their 40s and 50s, maybe even their 60s, and that after years of paying premiums, the people would get tired of it and drop the policies before they ever became old enough to make claims. But the carriers were wrong. People kept their policies, and as they say, the chickens have come home to roost, and the insurance companies are receiving far, far more claims than they ever anticipated. And they're, as we'd say, the book of business, the long-term care book of business for the insurance companies is awash in red ink. And so they're spending more in paying claims than they are in receiving premiums, and they're doing whatever they can to deny claims. When the policies were first issued, they had provisions in them that were very effective in preventing people from successfully making claims. For example, policies would have what we would call a stonewall provision, that people couldn't get over that stone wall to make their claim. They'd have provisions saying that before you could make a claim for long-term care benefits, you had to first have a 3-day hospital stay, followed by a 30-day stay in a skilled nursing facility. Well, sometimes people met that requirement, maybe after having a significant surgery, having an accident. But let's imagine somebody who is slowly slipping into dementia from Alzheimer's. There's no reason for a hospital stay. There's no reason for a skilled nursing stay. And so the result was claims were denied, and the policy provisions allowed those denials. I've been a lawyer my entire career in California, representing people with long-term care claims in California primarily, and I know the history of what California did in response to those problems. In the 90s, the California legislature started to enact prohibitions as to what could and could not be in long-term care policies. Those stonewall provisions were outlawed, and they were voided so that people who needed care could start to make claims and receive it. However, the insurance companies' desire to avoid paying claims never went away. So they came up with new reasons. So in today's environment, we're dealing with new reasons for denials. The insurance companies are able to basically move faster than the legislature and insert new policy provisions which will allow them to deny claims. An example, which I think will explain what they do. People with dementia or Alzheimer's make up a significant portion of those making claims for long-term care benefits. And they're not often physically ill. They just are not safe to care for themselves because they just are not cognitively there anymore. If they were trying to cook, they could burn the house down, they could walk out in traffic, other problems. A frequent resource are residential care facilities for the elderly that are aimed at caring for people with Alzheimer's. They're often in private homes, and in California, they're usually limited to 6 residents. Well, what the carriers have done is say, well, we'll pay for that as long as the residence is supervised on a full-time basis by an RN. Well, that provision is not outlawed by any legislation in California, but for the most part, these residential care facilities can't afford to have an RN there on site 24 hours a day, and it's not necessary. So a long answer to a short question is that people often will not understand the terms of their policies when they're putting their spouse or their parents into a facility. They don't get approval from the insurance company for the facility before moving their parents there and making claims. There are many other reasons. These policies are typically divided into 2 concepts. One is somebody is unable to perform the activities of daily living without substantial assistance. And those activities are typically bathing, shower, bath, toileting, getting to the bathroom by oneself, or if one is incontinent, be able to change themselves and clean themselves up. Ambulating, which is merely walking, transferring, which is getting in and out of a bed or a chair, dressing themselves, and eating. And eating, I'll be clear, is not making one's own meals. It is bringing fork to mouth, from plate to fork to mouth. If policies are different, there's either a requirement that someone can't do 2 or 3 of these to trigger the benefits. The other half is that someone has a cognitive impairment, that can't be left alone due to their own safety or the safety of others. So when you make a claim, you've got to prove an inability to perform 2 or more ADLs safely or without the assistance of others, or that one has cognitive impairment. And it can sometimes be difficult to prove to the insurance company's satisfaction. From there, we get into the fact that these policies are governed by state insurance law, and every state has different laws. There's a concept known as insurance bad faith, which, if proven, which is basically the unreasonable denial of an insurance claim, an insured can bring suit and recover damages well in excess of what's owed under the contract. Some states allow it, some states don't. In the states that allow it, such as California, Arizona, Nevada, Texas, a lot of the southern states, there's a lot more in the way of protection for insureds and remedies, and carriers are often afraid to deny claims because of the ramifications. In other states, many in the Northeast, where insurance companies have a lot of sway, Connecticut, Massachusetts, New York, remedies are not available. Now, actually, Massachusetts, they're available. I misspoke. But New York, Connecticut, some of the other Northeastern states, they're not available. Specifically, the carriers will look to find loopholes in their policies or evidence they can cherry pick to say this person does not need the care or is not receiving care that is eligible. Policies will sometimes have language saying the care, let me back up. There's a number of different kind of policies that provide different benefits. Some provide home care benefits, such that if you want to stay in your own home, for example, you may have 2 married individuals, one of whom is fine, the other needs care. The spouse who does not need care should not be responsible if they bought one of these policies for caring for their spouse. They want to bring in a caregiver. Some of the policies will say the caregiver has to be licensed to provide care in the state in which the care is provided. Well, that's fine, except that in California, for example, for many years, there was no license to be a caregiver. And the type of care that is given is often not something that is required of a licensed vocational nurse, much less registered nurse, you could bring in someone with a high school diploma to just stand there while you're taking a shower to hold you, to make sure you don't fall, to help you get in and out, to help you get dressed in the morning, to walk next to you when you're walking around your home or apartment to make sure you don't fall. That doesn't require a license, but the insurance companies would sometimes put in a licensure requirement knowing that there was no license, and they would deny claims on that basis. So these are just some of the examples of how insurance companies would find ways to not pay these very valid claims.
So you actually, I think, answered the next question really, which sort of was, how does hiring a firm like yours, or yours specifically, help clients navigate some of the particular challenges of long-term care? But the next question is, could you share some examples of specific cases in which Kantor & Kantor successfully resolved one of these issues? So maybe you could combine them.
Typically, the denial of a claim is very involved, and it would take a long time to go through the facts. There were policies written years ago that would pay if somebody went into a facility. However, these policies provided what was called an alternative plan of care, that if somebody didn't want to go into a facility, that they wanted to stay at home with their spouse, the insurance company agreed to look at what would be called an alternative plan of care, that if they could spend less money to care for the person in their own home by bringing in a private caregiver, they would be reasonable and work to approve this alternative plan of care. But the insurance company that had this in their policy came to realize that often the spouse that didn't need the care very, very much did not want to put their spouse into a facility, and would actually forego the benefits if the insurance company said, no, we are not approving your alternative plan of care. We're not going to agree. And since the policy says we have to agree, we're not paying for it. And often the insured would forego the care and pay for the care themselves. Other insureds came to us, and we took these cases to court and saying that there is an inherent duty of good faith and fair dealing in every insurance contract, and that when they put a provision such as an alternative plan of care into a policy, it's a promise to be reasonable. And we were able to successfully argue to courts that if the insurance company could pay less if the person stayed in their own home than going into a facility, and that either source of care was appropriate for this person, it was basically a breach of the contract and a bad faith breach for them not to act reasonably. And the courts agreed, and the insurance company changed its position and changed its, I won't say policy, changed its internal rules and implemented procedures to look at these claims on a reasonable basis and decide if it was appropriate to give this person care in their own home. Absent in this case, the insured spouse or child coming to us, this never happens, because the insured is never going to be able to convince the insurance company to change their position. It's going to take the threat of litigation. And I'll be honest, people come to us all the time and say, my spouse or my parent has been denied a long-term care claim. Will you write them a letter? And we've stopped doing that 20 years ago. We found that a letter with the threat of a lawsuit was given the back of the insurance company's hand. So instead, we just filed the lawsuits and found them much more receptive to acting reasonably once they knew they had been sued and had to hire attorneys.
What right do policyholders have when the long-term care claim is denied? How can they effectively advocate for themselves when they're in this situation?
As I explained earlier, all 50 states have different sets of laws that govern these kind of policies. There's very little in the way of any national law unless the policies were issued by the federal government, which did provide coverage for its insureds. Although often, even in those cases, if the federal government purchased coverage through insurance companies, state insurance law would probably still govern. So to answer the question on behalf of insurers across the country would take 50 different seminars or podcasts. I can speak to California. California provides more protection for its seniors than for any other group of people. And it has a whole section of the insurance code that deals with nothing but long-term care policies. It also has laws regarding elder abuse. And if an insurance company unreasonably denies a claim, there are remedies beyond obtaining the contract benefits by going to court. However, I would caution a listener that the mere denial of a claim for long-term care benefits is not by definition bad faith. There are many circumstances in which the insurance company is right. I would say that we probably turn down half of the requests that are made of us to take on somebody's case. People sometimes will exaggerate their symptoms in order to get funds. And we like to represent credible, honest clients. So there are situations when the insurance company is right.
For these next questions, really, you answered them. They're about specific tactics and negotiation strategies that you find particularly effective in dealing with insurance companies, specifically with long-term care. But you did, you mentioned a few things.
Well, something that we do is to video the insured in their home or in the facility to demonstrate to the insurance company who it is they're really dealing with. Because from their perspective, it's just a name and on a piece of paper. And we think by showing them a video, it humanizes our client, and it also reminds them what a jury will see if the case gets to court. But video is a two-edged sword, as we could talk about. But there are situations where people make claims, and the insurance company will question the veracity of the person making the claim and will send out a private investigator to conduct surveillance. And sometimes that surveillance shows that the insured is exaggerating their symptoms, and they'll use that against the insured. At the same time, I would say that sometimes the insurance company sends out an investigator to conduct surveillance. That surveillance is conducted, and the insurance company says, aha, see, we've got you. And we look at it and say, that tells you nothing. An example I have is I have a former client who was a dentist with significant Parkinson's. And with a caregiver's assistance, he was able in the morning, before his condition got worse as the day went on, get into his car, drive about a mile, and get himself out of the car with a walker to visit his son's grave. My client was 80. His son had passed away, I think, from a drug overdose at a younger age. And the insurance company took the position that the fact that he drove meant he didn't need care. Well, this man had fallen many times, was unstable in the shower, needed assistance to get to the bathroom, couldn't bend over without falling to put on his own shoes and socks. And we were ultimately able to convince the insurance company that they had made a egregious error, and they decided to pay his claim.
How important is it for individuals to thoroughly review their policies? And are there specific provisions or clauses within a long-term care policy that tend to cause problems or people overlook or should pay attention to specifically?
Well, one of them I mentioned is the provision about eligible caregivers and eligible facilities if they're put into a facility. I'm actually dealing with what I consider to be a ludicrous defense now, which is in a policy, whereby a couple in their actual early 90s had coverage for over 30 years, and the wife had been diagnosed with dementia. And the husband wanted to bring in care into his home for his wife. He was also 90 and felt he could no longer really take care of her safely. but they'd both been school teachers, their finances were limited, and he didn't want to incur the expense until he knew the caregivers would be approved, and he knew that the insurance company agreed that his wife needed the care. So he made the claim, and the insurance company investigated and said, no, your wife is not that impaired that she would be unsafe to be left alone. And this man and his children aggressively appealed it, got support from their doctor, explained that they were looking at an old diagnosis from a psychologist, and the updated records showed that this woman really needed the care. The insurance company, again, said, no, we're not going to approve this claim. They came to me, and I thought the decision to deny the claim was completely outrageous. And we filed suit. And the insurance company moved to dismiss our lawsuit, saying, before we have to pay, you have to spend money for 90 days to pay for a caregiver. Only then do you have a viable claim. And under the terms of the policy, they were correct. However, the insured was saying, what happens if I spend this money? You agree that after the 90 days, you will be paying the claim. And the insurance company's response is, all we're telling you is that we don't find your wife to be impaired. So he said, well, then I'm not going to spend the money because I don't have it if you're not going to reimburse me. But then they moved to dismiss it because he hadn't spent the money for the 90 days. Actually, tomorrow, the judge is going to decide whether there's any basis to the insurance company's position. We think it is beyond ludicrous. Maybe by my next podcast, I'll have an answer to what the judge said. But we anticipate a favorable decision. And as I said, this is what I think is a classic bad faith case where the insurance company has been told it's looking at outdated medical records. It's using a physician to review the outdated records who isn't even qualified to opine on this person's care. They never talked to the person. They never came out and examined the person. And these are the things that result in, from my perspective, large jury awards or very large settlements.
So what steps should somebody take immediately after being denied in their long-term care claim in order to potentially protect themselves or file an effective appeal?
If I can answer a question you didn't ask, I think the question would be, what should they do when they make the claim to avoid having it denied? And it is to do everything possible to properly document the need for either assistance with activities of daily living or to document that the insured individual is cognitively impaired and unsafe to be left alone. Or, as I discussed earlier, to confirm in advance with the insurance company that if they put their relative in this facility or that facility, that it will be a covered facility, that the caregivers they're going to retain are appropriate. Many policies will not cover care provided by a spouse or a child. And earlier you asked me about reading the policy. Those are provisions you need to read to make sure that the care provided is going to be covered. I should explain here, there are two basic kind of policies. One is an indemnity policy, which means that if you establish you need care, the insurance company pays a set amount of money either per day or per month for your care. You don't have to spend it on the care. For example, if you bought this policy and it pays $6,000 a month and you decide that your spouse can provide the care, that's fine if you have an indemnity policy. The other kind of policy is a reimbursement policy, whereby you have to demonstrate that you've expended money for care and the insurance company reimburses you for the amount that you expend up to the limits specified in the policy. Now, something else that should be looked at when reading a policy is what is the actual benefit being provided. These policies, as I said, mostly sold in the 80s and 90s, and the benefits paid back then were relatively low, maybe $100 a day, maybe $3,000 a month, but they almost uniformly included an inflation factor, whereby they would add 5% annually to either a daily max, a monthly max, or even a lifetime max, if there was a lifetime max. So, and these were compounded as well. So if it was $100 a day in the year 2000, and it was a 7% inflation factor, that amount would double every 10 years. So over 20 years, that would become 200 and then 400. So the benefit from the year 2000 in 2020 could become 400. So it's obviously important to know what your benefits are. Other provisions that you might want to look at are, for example, the lifetime max. Some policies were written with no lifetime maximum. Others have a maximum such that you want to make sure to use the benefits wisely. For example, if you've got a lifetime max, and you can limit the care needed to when the insured is awake, so that maybe when they're asleep, you're not paying for somebody to be in the house. That's much cheaper. Those are things that should be considered. That's not really an attorney's job. That would be more of a financial advisor to advise on how to properly use your benefits.
So being aware that there are constant changes in both the long-term care and long-term disability space, what are some current changes, regulations or laws that policyholders should be aware of?
Well, there really, at least in California, there have not been any significant changes in the law in the past 20 years. However, there are constant judicial interpretations of the law. The alternative plan of care cases I talked about were litigated in the past 15 years. And it took a judge to interpret the policy and determine that our argument was appropriate and that he would uphold our rationale as to why the claim should be paid. But when a judge makes a decision at a trial court level, it doesn't become law. So I wouldn't say there really have been all that many changes. It's more a matter of inventive lawyers looking beyond the four corners of what it says in a policy to apply an interpretation that fits the facts and circumstances of an individual's circumstances.
Last question for today. What are the most common misconceptions that people have about their rights regarding their long-term care policy? And how do you address these misconceptions when you deal with your clients?
Well, I would say this is a situation where there are misconceptions, but they underestimate their rights. That they don't understand, at least in California, insurers often don't understand the concept of a bad faith lawsuit, and that if the denial is egregious enough, they could conceivably recover damages well in excess of the amount that should have been paid on the claim. We remind our clients that these cases are decided by juries, and juries are humans, and they are looking at the insureds, if they're honest, if they're credible, as though these are their grandparents, and that this insurance company that very willingly took in benefits for 10, 15, 20, or even 30 years should be just as willing to pay a valid claim as they were to take in premiums. And they get very upset when they feel the insurance company is unreasonable. I am actually unaware of any case going to a jury in California in the last 10 years on a long-term care case where the insured won. Now that may shock you, thinking insureds always lose. Well, the times that the insurance companies take these cases to court are when the insured says to them, I have a horrible back, I can't do this, I can't do that. And the insurance company goes out and has surveillance of them driving, going to the grocery store, going to lunch alone with no caregiver. And the insurance company, rightfully in my mind, will stop paying claims and will seek to get money back because they feel they've been defrauded. But when the insurance company recognizes that they're in the wrong, it's my experience, they pay enough money to settle claims to avoid going before a jury because they're afraid of the consequences. In the first one of these cases I ever handled, it was sometime around 2004. The insurance company took a position that was completely outrageous. It's a relatively long story, but basically a caregiver gave them a summary of what she did every day, and she detailed it in exquisite detail on the first day, then referenced her detailing from the first day every day thereafter. And the insurance company just denied the claim. And I had a younger lawyer who was telling me, you're not going to believe what I'm finding. And I'm listening and I'm saying, there's more to this story. That can't be true. And eventually I looked at the file and it was true, and went back to Chicago and deposed a high school graduate as to the rationale for the denial of this claim. And halfway through the deposition, the lawyer said, we're done for today, and took as witness and left, which is a rather unusual thing for a lawyer to do. And they they begged for a settlement conference. And at the settlement conference, they offered my client, who had been denied about $25,000 in benefits, $1 million to settle her claim. And I said to my 90-year-old client, I think if you turn this down, if we go to trial, I'll get you at least $5 million. This conduct was that outrageous. And she said to me, and she was a bright woman. She had no cognitive impairments, but she was very frail. She fell. I mean, the actual story of her situation was she fell at home, and her daughter would call her every day at 3 o'clock. Her daughter was a school teacher, and she called her at 3 o'clock one day and talked to her. Everything was great. Right after the phone call, this woman fell in the bathroom and couldn't move. This was I fall and I can't get up. Didn't have a cell phone back then, didn't have anything. And her daughter had called her 24 hours earlier, and the next day when she called and nobody answered, she rushed over to her mother, found her in the bathroom on the floor, unconscious, got her to the hospital, and she was fine after a week in the hospital, but the doctor said she cannot go home and be alone. It is not safe. And so the insurance company just refused to pay benefits on that situation. So I said to her, if you turn down this $1 million, I think I can get you $5 million. And her response to me was, how long will that take to get to trial? I said, probably a year or two. And will they appeal? Yes, they probably will if you get $5 million. And how long will that take? Well, another year or two. And she said, I'm 90. I'd rather take $1 million now than have a jury award $5 million after I'm dead. Let's just take the money and go on. And the insurance companies, in this case, they were offering $1 million, and it was not an unfair amount, given that it was only $25,000 denied. And it made the woman happy. She was able to, help take care of her grandchildren in college and things. But I guess the point of this story is that seniors are protected in California. If they have a valid claim and the denial is invalid, the insurance company is going to step up and settle the case. But only if the insured comes to see a lawyer with experience in this area who knows what he's doing. I often tell people, don't hire a lawyer who is not known for taking your kind of case to trial. Well, in the long-term care world, you can't look for them because they're just not there. You need to find a lawyer who is litigating them and can discuss with you his experience or her experience and successful settlements, and that they have a full knowledge of the law regarding long-term care.
Are there any tips or advice that you could give in the claims process to avoid, having it denied and ultimately needing a lawyer? And when is it that you do decide that you absolutely need a lawyer? Is it after a denial, during an appeal, after the loss of an appeal?
Well, okay. Speaking in California, the most important thing for an insured to do is twofold. One is to understand their policy, and that may require talking to a lawyer at the outset to get the policy terms explained. We do that at no charge. We just believe in helping people. The other is making sure your doctor is properly supporting your claim. Doctors are very busy, and we often recommend asking your doctor to write an exhaustive letter explaining why you need this care. The insurance companies often hire nurse assessors to come in to basically run through the ADLs, the activities of daily living, with the insured. While they're dressed, they'll have them pretend to get in and out of a shower. If they can, they'll pretend to have them get on and off the toilet. They'll have them demonstrate whether they can dress themselves, get in and out of a chair, eating. Though, as I think I said earlier, I've never seen a claim where somebody who couldn't eat had a claim denied. If it's that blatant, they pay the claims. But we often use that as a technique to get a claim paid. We'll find a nurse assessor who does assessments for insurance companies, hire that, typically women, but I guess there might be men out there too, to do an assessment. We videotape it and send it into the insurance company and say, this is why my mother, my father, my spouse needs the care. So you want to give them adequate information. Adequate's an inadequate word. You want to give them full information, to give them no option but to support the claim. And you want to also, as I discussed earlier, make sure that the insured is in the adequate facility, that's proper facility covered by the policy, and that the caregivers, if they're at home, are of the right type, and that the policy provides for home care benefits or provides for facility benefits. Some do and some don't. And it's sometimes hard to understand the policy terms without talking to a lawyer. When do you need to hire a lawyer? My response is when you get a denial letter. If they're denying you or even not making a decision for 6 months or 5 months, go see a lawyer. You asked about when do we appeal. If the insured has done even an adequate job of setting up their claim and the insurance company is not properly investigating, we don't submit appeals, we file lawsuits. Because the insurance company bears a heavy burden to perform what we call a full and fair investigation before deciding to deny a claim. If the insured gives them their doctor's name and an authorization, the insurance company better be talking to the doctor. If the insured gives them the name of the caregiver, they need to talk to the caregiver if they have questions. They can't just say, well, you didn't give us enough information. The insurance company has to ask for what they need and follow up on it. So if you're denied, contact a lawyer. And, this is the age of specialization. If you're denied a long-term care claim, you don't want to hire a lawyer who is a personal injury lawyer, who is a divorce lawyer, who's a real estate lawyer. You want a lawyer who focuses their practice on this area of law, insurance law. It's complicated, it's specialized, there's traps for the unwary, and you don't want a lawyer who's going to step in the trap because this is the first case he's handled.